Good afternoon. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada.
Good afternoon, Montana. I am Erin Lageson. I am the presiding judge of Department 3 of the Oregon Court of Appeals.
Good afternoon, Montana. My name is Steve Jewett. I'm a county court judge in the 9th Judicial Circuit of Florida, which is Orange County, Orlando.
And students, you may introduce yourselves.
I'm Paige Maynard.
I'm Garrett Rose. I'm Keegan Crowley.
I'm Bailey Chapman. We're all seniors at Laurel High School. Our instructor is Mr. Denny.
Great, thank you. So all right, yes, please be seated. So question number 2 is what we'll be discussing this afternoon. And it starts out with a quote by Thomas Jefferson. "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on in inference. Do you agree or disagree with Thomas Jefferson? Additionally, what are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty?" You may begin.
After a great deal of discussion, our panel does agree with Jefferson. A Bill of Rights is essential to the welfare of the people. Anti-Federalists felt that without a Bill of Rights to list and protect certain freedoms, the government would infringe on them. Every person is entitled to inalienable rights, those that are endowed by our Creator and guaranteed through our humanity. Freedoms found in the First Amendment provide a foundation for other rights. The American colonists had recently won their independence from tyrannical English rule. They wanted to guarantee that this new American government would not encroach upon their freedoms of religion, speech, press, and others. Therefore, a Bill of Rights is essential.
Federalists such as Framer Alexander Hamilton thought that the Bill of Rights was not needed. He stated that the Constitution itself, in every rational sense, is a Bill of Rights. Federalists wanted a strong central government, and Hamilton felt that a Bill of Rights would limit the federal government in ways that it shouldn't be. Many of the Federalist papers focused on the ideas of weaker state governments, stronger centralized governments, and the separation of powers within the national government. They supported the Constitution, but not the Bill of Rights. Anti-Federalists were the exact opposite. They supported the Bill of Rights, but were entirely against nationalization or an American national government in general.
Federalists saw more of the disadvantages to a national Bill of Rights. They felt that a Bill of Rights would place limits on the powers of the national government and restrict the government in ways similar to the control that they had just escaped from in Great Britain. Per the 10th Amendment, the people and the states reserve any powers that are not given to the national government through the Constitution. This would mean that it would be up to the states to protect the rights of their citizens. If they supported any Bill of Rights, it would be that of the states. This is because the founders wanted most aspects of life to be controlled by those who were closest to the issues. Anti-Federalists viewed this issue on the opposite spectrum. They wanted a Bill of Rights held by the national government to safeguard their individual liberties. It is not unusual for the United States Bill of Rights to differ from different states' Bill of Rights. The National Bill of Rights is meant to protect citizens from national government abuses of power, not state. The National Bill of Rights is very important, but it doesn't tailor to the specific state's needs as their individual Bill of Rights does. State Bill of Rights dive deeper into the necessities of that specific state.
Another instance involving the Bill of Rights concerns incorporation through the 14th Amendment. Abortion and gun control would be modern examples of possible applications of incorporation. Applying this principle gives the government and the American people a standard for applying our rights. It outlines our basic human privileges and lessens confusions on where rights can be limited. On the other hand, this would imply that once the national government makes a decision on an issue, the state governments must comply even if they disagree.
Generally, the Constitution is a charter of negative freedoms. Understanding the difference between negative and positive rights is essential to comprehending the federal government's deviation from the nature and bounds of the Constitution. Negative rights give the people freedom from something. Someone's negative freedoms mean that other people cannot stop them from doing something and also restricts governmental action. For example, the right to be secure in one's home requires that other people refrain from entering someone else's home without permission. Positive rights mean freedom to something. Someone's positive rights mean that they have the right to acquire something with certain stipulations and action from the government. For example, people have the right to a trial by jury, which requires that the government provide the judge and jury and that the defendant must attend. Our panel believes that negative rights are intrinsic to the preservation of liberty. Liberty is defined as the state of being free within society from oppressive restrictions imposed by authority on one's way of life, behavior, or political views. This is verbatim the definition of negative rights. While positive rights are still important, they are harder to define and they require action for both the people and the government. Negative rights require that the people's natural rights are not violated by the government, prohibiting the government's action on such matters. As James Madison said in the Virginia Declaration, all power is originally vested in and consequently derived from the people. We are now ready for your questions.
What limits, if any, should be placed on rights listed in the Bill of Rights?
We don't necessarily think that, other than compelling state interest, that there is really any way to limit rights listed in the Bill of Rights, because we do believe that those are fundamental human rights.
An example of that is, you have your freedom to your religious practices. But an example of compelling state interest is the case of Smith versus Oregon, where he was stopped from using peyote in a religious practice because it was found to be that if something is illegal for an entire group of people, it's illegal for them regardless of their secularity.
Another example specifically involving the First Amendment about how our freedom to assemble has been taken away has been due to the COVID-19 involving like going to church and funerals for your family members.
Let's say you wanted to develop a new right, say like the right to, clean environment. Evaluate the best path for doing so. Does it make the most sense to do it through the state constitutions or through the federal constitution, and why or why not?
We actually talked a lot about what rights we would add, if any, in preparation for our state competition. And I think that it depends on or comes down to which right you would add to the Constitution. So an example of one that we talked about in depth would be adding the right or the explicit right to privacy in the Constitution. So I think if you were going to add that, maybe going through the national Constitution would be a better way of going about it. But if you were going to add a more intrinsic right, you could say, that might differ between states, it might be better to go about it from a state point of view.
What circumstances, if any, do you think should arise or cause the loss of the rights in the Bill of Rights?
As my colleague mentioned, with the COVID-19 pandemic, we have lost some of our rights specifically, or they've been questionably limited, our First Amendment rights. I don't agree with that at all. I don't necessarily think that other than compelling state interest, like we just previously mentioned, that there's any time that those rights should or could be limited.
On the other hand, to see a different point of view, the government is questionably limiting those rights for us to keep people safe. So, that's a time when those rights can be, questionably limited. But we did come to the agreement as a panel that we don't think that those rights should be limited at any time for any reason at all.
On the topic as well of rights and our liberties being limited, there's a great quote by Ben Franklin. He once said that those who give up liberties for temporary safety deserve neither and will probably lose both. I believe that's currently happening right now with COVID-19. As my colleagues have mentioned previously, we have lost, questionably limited rather, our rights have been. So.
Do you think that there are any additional negative rights that should be added to the Bill of Rights?
Yeah, we actually talked about this probably an hour ago. We talked about how the right to privacy is implied in our Bill of Rights, but it's never specifically listed. So we would add the right to privacy. And we think that that's a negative right because, it stops the government from infringing on your privacy. So.
What is the difference, if any, between rights added to constitutions through the amendment process and rights that are added through the process of judicial interpretation?
So I think judicial interpretation, offers a place for you to see both sides of whatever right you were thinking of adding. And so I think that with controversial issues, that would be the better path to take. So we talked about abortion in our prepared remarks, and I think if you were going to make any decisions on that would be one that would need to go through the judiciary branch before any decisions could be made on that.
Yeah, and on the other hand, to see the different point of view of that, if the Supreme Court is leaning towards one political party or one way of thinking, that can be a problem for people who think the opposite way. So even though it would be a better decision than just amending it into our Constitution, obviously it would still cause a problem with such a big problem like abortion.
I think the founders would have maybe wanted the people to have a say in it. The Bill of Rights was actually added to the Constitution as a demonstration of the power that the people were given. And so I think that if you give the people the right to vote and have their say on things that you're going to add to a document that largely controls the majority of the points of our life, I think that that would be something the founders would agree with.
Stephen, you're muted.
The old guy forgets to unmute. You talked a little bit about that there's a right to privacy in some state constitutions. And I think it's pretty clear that it's easier to amend a state constitution than a federal constitution. I think we'd all agree with that. Is there any, because it can be, they can respond to political pressures and stuff. Is there any downside though to the rapid expansion of the state constitutions? I know that in some states it's over 100, 150 times it's been amended, and that just seems a little too much. Is there any, what downsides do you see to that nimbleness of amendment to state constitutions?
If you were to look at something that could be both a downside and an advantage to that, it would be that things would differ between states. That could be an issue. Say you live in Montana and you move somewhere where things are different. That could cause issues. However, I think that differing states, as we talked about in our prepared remarks, the Bill of Rights tailors to the needs of specific states. And so I think that having that ability to change just state constitutions is great in that way.
Yeah, we actually did see this specific difference when we were preparing for actually our first question for this national competition. Our Montana Bill of Rights actually gives a really specific and in detail quote about our education, and other Bill of Rights in states such as the California Bill of Rights, it doesn't even really give any specifics to any sort of education. So that's a pretty big difference. If you were to move schools, you actually have a problem, and if you can even get an education in that state, the difference in those Bill of Rights talking about education is pretty big.
Erin, did you have another question?
Sure. Of the negative rights identified in the National Bill of Rights, which do you think is the most essential to our liberty?
So we believe the founders created the First Amendment because those are our most important rights, such as the freedom of speech, freedom of religion. We believe those are the most important, and that's why they put it as the First Amendment.
Yeah, the freedom of speech covers a lot of other amendments, such as your right to vote. You think that voting is a part of expressing your speech, so you can't have amendments such as the 19th Amendment, which gave women the right to vote. You can't have that if you don't have freedom of speech in the First Amendment.
We talked a lot about how rights listed in your First Amendment play such a pivotal role in other rights that you have throughout the rest of the Bill of Rights. And so, as my colleagues have both said, that's why we believe that when the Bill of Rights was written, it was put first.
Great, thank you.
Great, thanks.
Well done, Montana. It was really a pleasure listening to you in your reasoning. You all were very all on the same page. Some teams, some of the team members felt one way, some felt another. It seems like you guys were pretty much on the same page with regards to your arguments and thoughts. And I thought your prepared remarks definitely were responsive to the question asked. And you answered every part of the question, which was good. You acknowledged, obviously, with regards to Thomas Jefferson, and you agreed with him. You mentioned and brought up basically, John Locke and just fundamental rights. And you guys stuck to your guns with regards to your belief that there should be no limitations on these fundamental rights unless there really is a compelling state interest. And when you answered all of our questions, even when we asked whether or not there should be it, in what circumstances, should there be limitations, you guys kind of stuck to your guns and you provided well-reasoned responses with regards to your positions. And I thought it was pretty good and well done. So good job.
Thank you.
I'd echo that. I enjoyed listening to your presentation. You talked about a lot of discussions you've had not in front of us, and I wanted to know more about those discussions. As Noreen pointed out, you presented a unified front, but it sounded like it took a while to get there, and I think that's completely the value of this program. I enjoyed your conversation, particularly your conversation about your own constitution, when you were able to illuminate us about what Montanans have chosen to govern their rights. And I thought it was interesting. I have to reflect on it, but I thought it was interesting your response to it doesn't make more sense to recognize rights through a judicial process or a political process, and you took the position that it made for a more controversial right, perhaps going through the judicial process, that was just an interesting thing to hear. I think a lot of people argue that a political process makes it easier to accept, and so you had some insights that I hadn't thought of before.
Yeah, great job. I enjoyed the statement. It hit all the points. It kind of took away some of our possible questions. I want to echo what Aaron said. I want to be in the room when you guys were hammering out what is going to be your positions, because I got a feeling that that was probably really entertaining to watch you guys go at it, hammer and tongs, figuring out okay, we got to have a position here, and what is it? And I like my position, I don't like yours, and all that kind of stuff. I wish I could have seen that. It would have been, I think, a very interesting discussion. I'm kind of a federal constitution versus state constitution. I'm interested in that stuff, and I usually like to ask questions about that. And the question I asked you about, one of the downsides, one of the things that I think is problematic is that because it can be done so quickly, that something that's a hot political hot button right now gets into a constitution, and then maybe that hot button is gone in a couple of years, and now it's in the Constitution. So that's kind of something to think about as well. But I think that your point that you made, you talked about the good sides to that, and I think that you handled that very well. We had another school from Hawaii. When I asked that question, they talk about how in their Constitution they're required in their schools to talk about culture, about their Hawaiian culture. And so, there are definitely a lot of really good sides, because as you said, you can tailor it more to the people there. But thank you very much. I appreciate it. It was really well done. I enjoyed it.
Thank
Thank
you.
you.
Good luck, guys.